Hello, welcome back, everyone. I see we again have lots of participants. We're very glad that you're following this interesting discussion. I'm very happy to introduce the fourth and last panel of this workshop, which will address the topic of the role of science in international environmental and climate change litigation. So at the beginning of the afternoon, we addressed the national perspective, looked at cases before climate change related cases before national courts. And now indeed, we will move to the international perspective, broaden the perspective a bit beyond climate change litigation, because we don't have so many examples yet, although some very promising developments are of course occurring, about which we will be hearing this afternoon. But also we will have indeed perhaps some insights about the broader topic of the role of science in international environmental cases. So I'd like to just introduce the chair and then give the floor over to you, Antonio. So Antonio Navarra, Professor Antonio Navarra, is the president of the Euro-Mediterranean Center on Climate Change and a full professor of this is such a difficult word, someone else can, yes, can you fill this in? Meteorology, voilà, and climatology at the University of Bologna. Excuse me, you can see the communication between lawyers and scientists is not easy.
A lawyer can be very complicated too.
Exactly. Well, he has been active in this field for many years and has published more than 100 publications. Professor Navarra has held visiting positions in institutions in the US and Europe and has been an affiliate scientist at the National Center for Atmospheric Research in the United States for many years. So with this, over to you, Professor.
Thank you.
Navarra.
Thank you very much, Christine. Thank you, Roberto, for organizing. Do you hear me? Is that okay, the sound? Yeah. Thank you for organizing this very interesting workshop that I think is looking at the aspect of climate change that is going to become more and more relevant in the future, as it's becoming clear that climate is something that has multiple impacts and effects in unexpected places. And so here we come with the lawyers discussing climate, that I think is something that people would not expect 15 years ago. So I think that therefore is a very interesting moment for me. It's also very interesting because one of my old professors used to say that at a certain age, you should always only go to meetings of which you know nothing. So this is perfectly for me because I know nothing of what is going to be discussed today. So I think I'm the perfect chair. So let's not waste time and let me introduce the panelists today. Today we're very fortunate. We're with us Sandrine Maljean-Dubois, and I apologize if I'm massacring names this afternoon. She's a researcher at CNRS in France, and she's teaching international environmental law at the Faculty of Law and Political Science and Aix-Marseille University. She's an expert in the areas of environmental law, international environmental law, biodiversity, and climate change law, with several books and numerous articles published on these topics. She's been a visiting professor at several universities around the world, and in 2019, she has lectured at the Hague Academy of International Law on the topic International Law and Biodiversity. And she's been involved in the IPCC process, both IR5, IR6 as an expert reviewer. She has been involved in various international negotiation processes on climate change, including the Paris agreements and I assume the various COPs. After that, we have Marc Villers. He's a senior member of the Garden Court Chambers in London and also a member of the Irish Bar. Marc specializes in planning and environmental law, public and administrative law, human rights, and discrimination law. Marc's environmental law practice is extensive. He regularly acts for NGOs and campaigners in climate change cases in both UK and abroad. And our third speaker is Monica Feria-Tinta. She's a barrister at the Bar of England and Wales, practicing from 20 Essex. She's a specialist in public international law, regularly acts for sovereign states, government, corporate bodies, non-governmental organizations, individuals in contentions and advisory proceedings across the full spectrum of international law. Monica has acted, advised on cases before several international courts and tribunals, including the International Court of Justice, UN organs, regional courts, international investment tribunals, UN special rapporteurships, and diplomatic fora. She is counsel in several climate change cases, including the Torres Strait Islanders case before the UN Human Rights Committee, dubbed the world's first climate change human rights case. So as you see, it's a very varied panel, very interesting panel. These are very powerful people. You don't want them to sue you in any case, so it's better you have them on your side. It's very clear to me. So I think we're going to have a very lively discussion, and I think at this point we're going to start directly with the presentation. I understand Sandrine is the first, so Sandrine, you have the floor.
Thank you for giving me the floor. I need to share my presentation. Is it okay? Can you see it?
Yeah, fine.
Okay, perfect. I would like to warmly thank Christina, Roberto, Ivano, and Jean-Pierre for their very kind invitation to this fascinating workshop. Looking at the program, I realized that I'm the only one who will not talk about climate issues specifically. And for good reason, because to date, the International Court of Justice has never been presented with a climate case. However, the organizers rightly included the ICJ in the scope due to its general competence to decide all matters of international law, including international environmental law. A climate case could arise before it in the future, and some seem to be thinking about it. That's why it is interesting to analyze the role of science in environmental cases before the court. Is the court equipped to deal with the future climate litigation? And to what degree is it open to science? At the very outset of my presentation, I would say that the environment is an area in which states have for a long time not been inclined to bring matters to the international judge. I mean, this is the case in general, because states are usually reluctant to participate in judicial settlement of disputes, but it is particularly the case in the environmental field. Yet, during the last few years, the International Court has been approached more and more often on environmental matters. It can largely be explained by the impressive quantitative development of international environmental law. It is not surprising that a development in international law comes with the development of case law. Actually, the court has been seized with several environmental cases. After its advisory opinion of 8 July 1996 on the legality of the use by a state of nuclear weapons in armed conflict, the ICJ gave 4 important judgments regarding this topic. In 1997, the Gabčíkovo-Nagy Maros project case between Hungary and Slovakia, where it has to decide whether the suspension of a dam project on the Danube by Hungary was necessitated or not due to a risk of environmental damage to the surrounding ecosystem. In 2010, the pulp mills on the river Uruguay, Argentina versus Uruguay, where the court has to decide whether the construction of a complex of pulp mills along the river Uruguay would pollute the river and damage its environment. In 2014, it rendered its decision in the whaling in the Antarctic case, Australia versus Japan, a case which is of great value for the topic of this conference on the role of science in international litigation, because the court has to decide whether Japan's whale research program in the Southern Hemisphere breached certain provisions of the International Convention for the Regulation of Whaling, or if its program was authorized according to the possibility for governments to issue special permits to its nationals to kill whales for, I quote, purposes of scientific research. And finally, in 2015 and 2018, the case on certain activities carried out by Nicaragua in the border area, Costa Rica versus Nicaragua, and construction of a road in Costa Rica along the San Juan River, this time Nicaragua versus Costa Rica. It was two cases, but one judgment at the end because the ICJ decided to join the two proceedings. Here, it had to decide on the environmental consequences of certain activities, dredging, construction of a road, in particular on two rivers and on wetlands protected by the Ramsar Convention. In all these cases, given the scientific character of the dispute and being faced with conflicting expert evidence, which one is scientifically founded, the court has been called upon to engage in scientific fact-finding in addition to traditional legal fact-finding. So, what can be learned about this ICJ case law regarding scientific aspects? I will try to answer this main question by focusing on two relevant tools. First, rules of evidence, and second, so first on the rules of evidence. Before the ICJ, the rules of evidence, burden, standard, method of proofs are inspired by the common fund of general principles from national systems and not by any particular national system. The parties play an important role in the mechanisms of proof. The court has consistently upheld that it is the duty of the party which asserts certain facts to establish the existence of such facts. Here, it should be pointed out that the court has denied that the application of the precautionary principle led to a shift of the burden of proof. It was in the pulp mills case. At the same time, the court plays a major role in establishing the truth and has a wide margin in assessing the probative value of the factual and legal elements submitted by the parties, according to the provisions of its statute and rules that you can see on this side. But in its first environmental case, the Danube Dam in 1997, the ICJ appeared quite reluctant to enter into scientific considerations, and it tried to avoid adjudicating on scientific issues. When it came, for instance, to the appreciation of the ecological consequences of the project, it considered completely opposing views of the parties, and it noted, I quote, that both parties have placed on record an impressive amount of scientific material aimed at reinforcing their respective arguments. It also stated that the court has given most careful attention to this material, but concludes, however, that, as will be shown below, it is not necessary for it to determine which of those points of view is scientifically better funded. In other words, the court found a way not to rule on this point, and this approach has been criticized. How can the court decide on the immediacy and gravity of environmental peril without accounting for the abundant scientific data that the parties submitted? However, the court has still remained cautious in the pulp mills case. Again, it has avoided taking a position on issues over which experts had expressed divergent views. The same applies to the whaling case or to the certain activities case. In the latter, the court observed that there was considerable disagreement amongst the experts on key data. which led them to reach different conclusions as to the total amount of sediment contributed by the road. As a result, again, it preferred to avoid making a deliberation on the value of the conflicting opinions by observing that, I quote, "The court sees no need to go into a detailed examination of the scientific and technical validity of the different estimates put forward by the parties' experts." We can understand that the court does not want to become a judge of science, but in such cases, it cannot also strictly limit its assessment to legal aspects. It has to be more active and to engage sufficiently in the examination of the evidence. As stated by Judges Sima and Alcazavne in their joint dissenting opinion under the pulp mill's judgment, fact-intensive cases with a complex scientific component require the court to go beyond its traditional methods of fact-finding. Therefore, to conclude on this first part, we can argue that the court's method of establishing facts and handling technical and scientific matters could be improved, in particular through a deeper involvement with fact-finding at the deliberation phase. On expertise now. The expert has become an important actor in the dispute resolution process in international law due to the increasing factual complexity of cases. Any error or fact would be particularly serious with far-reaching consequences affecting the interests of states and the credibility of international justice. That's why the functions and statute of the expert in a judicial context is so important. The International Court has a wide range of options in this regard. It has the power to decide to conduct investigations, to conduct expert appraisals, and to carry out site visits if it deems such measures necessary for the purpose of gathering evidence. According to Article 50 of the statute, the court may at any time entrust any individual, body, bureau, commission, or other organization that it may select with the task of carrying out an inquiry or giving an expert opinion. Experts can also be called by the parties to testify before the court. The practice is variable. Actually, the court has appointed experts in only 3 cases, which is very little. Without appointing its own experts, the court deprived itself of obtaining objective scientific knowledge. This apparent reluctance of the court to make more use of its powers may be attributed to the fact that if an expert appointed by the court gives an opinion which turns out to be not satisfactory to the court might then feel bound by this opinion. However, the expert opinions provided by the parties present a risk of bias, and the court should not hesitate to call on experts to help it assess the technical or scientific elements. In all the environmental cases I mentioned, it would have prevented the court from strong criticism. But it is worth noting that in the maritime delimitation in the Caribbean Sea and Pacific Ocean case between, again, Costa Rica versus Nicaragua, the court decided in 2016 to obtain an expert opinion entrusted to 2 independent experts, and it decided that the experts should visit the site. The decision may mark an opening of a new era on the use of experts before the court with a more proactive ICJ. Another frequent configuration is where experts have not been appointed by the court or by the parties, but have been part of parties' delegations and acted as scientific advisors or consultants to the parties. It was the case in the Danube Dam and in the pulp mills cases. Here, the parties enjoy a large degree of autonomy. The procedural safeguards do not exist for experts speaking to the court as counsels. In particular, experts are not cross-examined by the opposing parties. In the pulp mills, the court expressed its disagreement about this practice, noting that it is that it indeed considers that those persons who provide evidence based on their scientific or technical knowledge should testify before the court as experts rather than counsel, so that they may be submitted to questioning by the other party as well as by the court. And as stated by Judge Greenwood in his separate opinion, such a practice is both unhelpful to the court and unfair to the other party. Lesson learned, as seen in the Whaling and in the Road case later, experts of both parties testified only in their capacity as experts and did not advocate for the parties. However, while the court in the Road and Certain Activities case or in the Whaling case did not appoint its own experts, it showed itself to be highly engaged with the evidence in indicating the kind of expert evidence it will be interested in hearing from, carefully questioning counsel and the experts at the oral hearing, and facilitating vigorous cross-examination of the experts according to a detailed procedure of examination, cross-examination, and re-examination. To conclude, we have seen that the court, despite all the means at its disposal, has long remained very cautious, prudent, and too passive. But it seems to be more and more keen to enter in complex technical and scientific issues and to develop a robust methodology. It is, above all, a matter of will, and the will seems to be more and more there to make greater use of the provisions of the court's statute and rules. Moreover, the court could draw inspiration from other fora like the dispute settlements panels and the appellate body of the WTO. To me, the court is almost ready for a climate case, or at least to give an advisory opinion on this matter and clarify states' rights and obligations in this area. Thank you very much for your attention.
Thank you very much, Sandrine, for this very clear presentation that shows clearly how the difficulty of searching for the truth is something that we share with all the scientists. And we know it's not an easy endeavor. So it's very interesting to see how a different context of intellectual ideas and principles approach this problem. I think we'll have a question-answer question at the end. So I think we can go to the next speaker, that I think is Marc.
Thank you, Antonio. And I hope everybody can hear me. Thank you very much for your kind introduction, Antonio, and for Bickel for organising this great event. I was watching yesterday and today, and it's been fantastic and really useful from a lawyer's point of view to hear yesterday the scientific experts giving us something of a climate change tutorial, and today to hear of the experiences and expertise of different lawyers, and to be part of this panel. So I'm going to address the role of science in the context of climate litigation in the regional European courts. And by that, I mean the Court of Justice of the European Union and the European Court of Human Rights. And I do so obviously from a lawyer or barrister's perspective, but also as somebody who was a member of the team that issued the first ever climate change case before the European Court of Human Rights. That's the Portuguese youth climate change case, the Duarte Agostinho case, which was issued in September of last year against 33 member states. And I'll be focusing primarily on the scientific evidence adduced in that case. But I begin first with the Court of Justice of the EU, and there were two cases that I'm sure many, if not all of you, will be familiar with, that I'm going to focus on. The first is the case known as the People's Climate Case, a case brought by Armando Carvalho and others against the European Parliament and the Council of the EU. And it was brought by a number of applicants who challenged three pieces of EU legislation, which were designed to enable the EU to meet overall greenhouse gas emissions reductions, which the applicants considered to be far too low. The reduction target that they were challenging was 40% by 2030 compared with 1990 levels. And they relied upon scientific evidence for that case presented by the independent scientific think tank, Climate Analytics. And that evidence, unfortunately, didn't get assessed by the Court of Justice of the EU because that court concluded that the applicants didn't have standing, that they hadn't complied with the very strict standing requirements of the court to bring the case. They hadn't passed what is known as the Plowman test. But Climate Analytics in that case had adduced evidence or produced a report which showed how the families of the applicants that presented the case would be impacted, and indeed were being impacted by climate change, and also what the EU could have done in order to further reduce emissions beyond the 40% inadequate target. So that case, I'm afraid, fell, as it were, at the standing hurdle. The same fate befell the next case, the case brought by Peter Sabo and others, known as the EU biomass case. And it was brought back in 2019 and challenged a piece of EU legislation that allowed for the burning of forest biomass in order for the EU to meet its climate change requirements. They relied, the applicants, on evidence, again, scientific evidence, that wood-burning power plants release more carbon into the atmosphere per energy than coal plants, and they sought an annulment of the EU legislation relating to forest biomass. The problem again for them was that the Plowman test, or the test of standing to bring a case before the EU, is a strong one or a strict one, and they didn't cross the hurdle that the court applies in any given case. And unfortunately, their case too went the same way as the People's Climate case. So I'm going to turn now to a case which hasn't been yet determined, but is before the European Court of Human Rights. And it's not the only climate change case. For a number of years, there were no climate change cases brought before the Strasbourg court. And then, like buses, you wait for ages for one to come along, and then 3 or 4 come along at one moment. I'm sure that's the experience of everybody on this webinar. And that's exactly what's happened in Strasbourg. We have the Portuguese youth climate case. We have a case brought by an Austrian individual who is suffers from a particular medical condition that is susceptible to temperature rise. We have a case brought by Swiss elders, elderly women who are particularly affected, they say, by climate change, and they adduce evidence to that effect, having failed to succeed in their national courts. And then we have the case brought by Greenpeace Nordic and a number of Norwegian youth, which seeks to challenge the Norwegian government's decision to issue licenses for the drilling of oil in the Arctic region, known as the People Against Arctic Oil case. These cases, together with the Portuguese case, are at a fairly early stage of their proceedings. But if I can turn to the Portuguese case, it is a case brought by 6 Portuguese young people who all complain that the rising temperatures which exacerbate wildfires in Portugal are caused by climate change and caused by the emission of greenhouse gases by not just their own national government, but 32 other member states. And they say that with the benefit of scientific evidence, again produced by Climate Analytics, that effect, or those effects, are not being properly addressed by the 33 member states that they challenge, and that the impact of climate change interferes with and puts their lives at risk. It also affects their private and enjoyment of their private and family life. It also affects their physical and mental well-being, and they argue that it has a disproportionate effect on them because of their age and the fact that they will live a lot longer and experience the far more dangerous effects of climate change than perhaps somebody of my generation. So they argue that there is a breach of their rights protected by the Convention, the European Convention on Human Rights, under Articles 2, 8 and 14 of the Convention. But the court itself has asked the parties to consider whether also their rights protected by Article 3 of the Convention, that being their right not to be subjected to inhuman and degrading treatment, are engaged. The evidence that they have adduced through climate analytics addresses a number of issues, and it's really used by the applicants and their lawyers to give the court a guide through the plethora of scientific evidence, a way in which they can navigate in a readily understandable way the scientific evidence that is agreed and underpins the Paris Agreement. What the applicants could have done but didn't do was take the scientific evidence one stage further and perhaps present evidence which might be disputed, arguing that in fact the IPCC and evidence and indeed the Paris Agreement doesn't go far enough. It was the view of the lawyers representing the applicants that the European Court of Human Rights would not involve itself in a dispute between whether perhaps 1 degree or 1.5 degree was the appropriate target that should be reached. Rather, it was thought that agreed evidence which the member states could not really argue with would be the appropriate way of presenting the case. So the evidence adduced by climate analytics gives that, as it were, pathway for the court to navigate its way through the scientific evidence that has been produced to date on climate change. It shows the trajectory to which the applicants will be exposed to harm and the risk to their lives, their health, their family lives, and the disproportionate impact it will have upon them compared with current generations. It also identifies specifically the impact of climate change on Portugal and the areas in which they live, highlighting the extent to which they will have to live with heat waves, record-breaking temperatures, and the likelihood of the exacerbation of wildfires through which they will have to endure air pollution and the like. And those elements will obviously cause an increase generally and put them at risk of an increase in the risk of fatality and respiratory diseases and the like. And so the evidence goes towards the question of victim status and standing. And it shows that the individuals will be directly, the individual applicants will be directly affected. If not right now, then certainly in the future. It also helps demonstrate, because it clearly identifies the fact that climate change is happening, is driven by human activity, and that each member state that is being challenged contributes to that harm, and that they ought to know that they are doing so. That in fact, the individuals are not just within the jurisdiction of Portugal, but are also within the, as it were, extraterritorial jurisdiction of the other 32 member states. So it goes to that issue too. And then finally, and as important as anything, the evidence shows, the scientific evidence shows that the individual member states are not doing enough to tackle dangerous climate change, that their efforts are insufficient or grossly insufficient. And climate analytics have produced a tool, which again, many of you will be familiar with, the Climate Action Tracker, which assesses across a range of various approaches to fair share and burden sharing, whether or not individual member states are doing enough to meet the Paris Agreement temperature goals. And in each and every instance, each and every member state, the 33 that have been challenged, we find that they are, at the very least, not doing enough to meet the 2 degree, let alone the 1.5 degree temperature goal. And in some cases, they're so far off track that we're looking more at the 3 to 4 degree range. And they're doing that in the absence of any globally agreed approach to fair share, and instead choosing their own self-serving approaches as to what a fair share should be. Now we're waiting for the applicants are waiting for the government to produce their submissions in response to the application and the evidence that has been adduced through climate analytics. And that evidence is due to be filed any day. In fact, I think it's undergoing translation in many cases at the moment. Once we see that evidence, and it will be publicly available, we will have 33 member states identifying exactly what it is that they say they are doing in order to tackle climate change. I think it's going to be absolutely, it's going to be fascinating to see the different approaches, to see exactly what they say they are doing in that regard. And I think that will in itself give the opportunity to individuals in the domestic, in the national courts in those 33 member states to hold their governments to account. So we're waiting with bated breath for that information to be filed. I think that's probably all I have time to say on the matter. Thank you.
Thank you very much. I think this is fascinating to see how this is developing within the legal framework of the European setup that at least has a context of agreement and treaties that regulates the relationship. So it's a different case from a full international, global event. So it's very interesting to see the contrast. I think it's also pointing to the issue of responsibility. In some sense, assuming that at some point we start establishing that we can make a case of responsibility towards emission, I think there is a question how deep the responsibility goes, because we're discussing at state level, but states do not emit anything, right? The emission comes from companies and actually from me, from individuals. So how deep the responsibility goes. So I think that's something that probably needs to be thought about. Okay, so I think that I would like to give the floor to our fourth panelist, Monica.
Yes, thank you very much for the floor, and I am very grateful for this opportunity and to join this very interesting discussion and very timely one. I'd like to start by perhaps throwing some of the issues that I think are relevant, from the perspective of a lawyer, and in this case, barrister, how to present this type of cases, and in what way scientific evidence has come across, or in what way can be relevant in this type of litigation. So first of all, I like to say, we lawyers don't invent the wheel. So it's not that, a case starts from scratch. And I say this quite knowingly because, like about 5 years or 6 years ago, there was this very important conference, and we were there, lawyers and then scientists. Some of them working and being very active with the IPCC work. And obviously scientists, when in this context presented facts in a very cautious manner, we're talking 6 years ago, And my feeling after that major meeting, was kind of mixed, because I thought it's going to be bloody difficult to put someone, for cross-examination if the approach is, is that cautious and still, with a lot of gaps on responses. But it's amazing how fast things has moved from there. And I like to start by picking something that perhaps may have been mentioned at in the earlier panel, but the case of recently that the Dutch court decided on the concerning a private actor, actually, the Milifonsi et al. And Shell, is an interesting case that can be relevant also for our discussion on international law type of claims, because there was a reliance on something that the judge called, and I quote, widespread international consensus. And that is that widespread international consensus that actually, she referred to. She actually didn't need to go or reinvent things, but rather referred to what it was seen as being, but many IPCC reports, etc., to be the international consensus. So my first point is that we lawyers don't reinvent the wheel. We don't have, in an international law type of dispute, to deal with anything that has to do with causation. So that's been a very wrong type of approach, when originally these type of cases were discussed. That's not what we are, we have to prove or we have to deal with. We deal with the state responsibility. And in doing so, we apply the rules of state responsibility under international law. And for what is relevant for us is issues of attribution and how we conceive them. For example, Antonio, you just said, what it would be the responsibility of the state, because the private parties are the ones that are, producing all these emissions. These are the big actors. But there, as an international lawyer, one is clear as to what the obligations of the states are. And if we are talking about, for example, the implementation of a human rights treaty, would be that the state has to ensure that those private parties comply with the respect of human rights in this specific treaty. So in other words, is the state the guarantor, and it's the state who has not just negative obligations, that is, not to interfere with, but also positive obligations, and that's to ensure that the rights in a specific treaty are complied with. And that includes the right to life. And within the right to life, we obviously have gone a long way to interpret that a healthy environment is linked and fundamental to be able to have the right to life in the positive sense respected. So moving on from causation, so first that dichotomy, causation, attribution. So why do we need scientific expertise, to prove our issues of state responsibility, that is attribution. So the second main point that I like to raise is that in order to use scientific evidence in this type of cases, it's going to be very important to be clear as to the procedure, because different types of cases involve different types of procedure. To give an example, the Torres Strait case, which is before the Human Rights Committee, it is a type of procedure that is basically written. There are no oral hearings, and therefore, in that way, most of the evidence is written, and including scientific evidence. And now compare that to other contexts or other types of proceedings where oral proceedings may be important. And Sandrine has just mentioned what is going on now with the International Court of Justice. I'm not at all surprised that Judge Greenwood made that comment back then, because him as a barrister, obviously, would have noted that. And I think that's definitely correct, Sandrine, that the trajectory of the court is going to be, towards being more forensic when it came to issues of evidence. I remember, for example, that in the case of concerning damage issues on the environmental case concerning Costa Rica and the River San Juan, there was a criticism that, a party had just mention a number of issues of the environmental damage. Actually, there was no evidence for that. So that's why the court eventually granted a very, I would say, a modest sum for compensation for environmental damage, the first ever time that the court did so. So it's going to be, I think, a far more forensic approach, but that can only take place in contexts such as contentious proceedings. If we talk about the possibility of advisory opinions generally, the input of scientific evidence may be of a different nature. I'm going to speak about two specific examples that I've been asked to speak about, but I think that it is worthwhile raise the point that, for example, before the International Tribunal for the Law of the Sea, which is potentially, I would say, a far more attractive forum to bring an interesting case on climate change. And potentially, I think there may be some things in the pipeline already. There are possibilities of organizations like IUCN to provide amicus. And they have done that in the past in a specific context on an advisory opinion. And the court can rely on this type of evidence directly. So the rules sometimes allow for different things. The same thing cannot take place before the ICJ for other reasons. But I can imagine that certainly if a climate change case were to reach ITLOS, even on an advisory way, certainly scientific evidence is going to be important. And let me give you one example in what way that was quite key. I participated in a case as an amicus concerning, this was before the Constitutional Court of Ecuador, but I think that what happened there may be replicated at the international level in certain contexts. So we have about quite a large number of amicus, including scientists. So we had a hearing and different amicus appeared explaining the position. This was about the protection of a cloud forest. There were some arguments on climate change because potentially the forest was to be destroyed. And then we had about over 20 something, scientific amicus. And it was the most fascinating thing I had seen so far, because they presented the evidence directly to the Constitutional Court. The court could ask questions. And I felt quite encouraged, by seeing the scientific community so involved, for example, in protecting biodiversity in that case. And I'm looking forward to see the outcome, the decision, which is going to be being issued very, very soon. Is the first rights of nature case to be decided by the Equatorian Constitutional Court. So I would submit the possibility of, I would say, scientific evidence can come in basically more or less 5 ways in this type of international proceedings. One is simply relying on IPCC and reports, and that has been the case, I would say, in most of these cases that are brought before international forum. The second thing is that many states obviously have already their own, I would say, and sometimes quite profuse analysis of the situation in a specific context. Let's say if there is a sea level rise issue somewhere, it's very likely that there is a lot of data already on the analysis of that. So in other words, scientific data that has been produced by the state itself. Evidence acted in national courts that can be actually used and referred in international forum. And finally, being able to instruct, own scientific expertise in a case. And that's something that certainly we've done in the Torres Strait case, where we produce specific scientific data. And that can be at 2 levels, because we don't have to prove all these causation issues that I just referred before. It may be about needing a scientific perspective as to whether a state is doing enough, right? So that has to be, it's not enough what a lawyer may say. It is quite important that is scrutinized by scientific eyes that could actually have a clear opinion as to, that is going to produce a certain outcome or not. Now, further point that I like to make, it has been quite successful, a couple of examples, and then I finish up with the 2 scenarios I was asked to refer to. In the Cerrejón case, which was a case on actually closing down a mine, an open pit mine that produces coal. This was in the COVID context. What was interesting was that most of the scientific data that had already been acted before the national courts could be used in a positive manner. And the second thing was that current scientific data and writings of scientists on how the air and the quality of the air may negatively impact on individuals was crucial for actually getting a positive outcome. So the special rapporteurs on environment and human rights call on the state to stop with the functioning of the mine during the COVID period. And I would say that the key element for that result was this scientific data, where it was clear, what was the impact on health on people when it came to these particles in the environment. So I say that that's an example of, in my own practice, of how science has been quite key for me to demonstrate something. And the other example, obviously, was the example of the biodiversity problem, where scientific data, again, and writings of a number of scientists, that were produced already for over a decade, were extremely important to be put before the court. When it comes to the UN Human Rights Committee, as I explained, it has a basically written procedure. So the main challenge basically is obviously the extent. We have I don't know how it's right now before the European Court of Human Rights, but we have a word limit to present a claim. It cannot go beyond a certain word limit, and that means that we have to be very we have to choose very carefully what is the evidence that we are going to put forward. Certainly written evidence by an expert, by a scientific expert in this case, was, I believe, a good decision. We'll see how the Human Rights Committee decides on that case. We are still waiting for a final decision, which will come anytime from now. Concerning the, but that's the limitation of a type of any treaty-based organ before the UN won't have the possibility beyond written evidence, to go further. Concerning the Inter-American System, there is important, if a case goes to the Inter-American Court, an important hearing where certainly scientific evidence has played a very crucial role. And I would say in a case of this sort, it will reassure the judges and will allow also to reply to questions. And I would say that scientific evidence won't recreate everything, because there's a lot of available information around, but I think it's rather being able to explain how that data applies to a particular case, and how maybe the information and the evidence that the state may have presented to defend its position needs to be scrutinized, looked into, and see whether actually it's a defense that is really replying to the allegations that are being made. I don't think that in terms of climate change type of cases there may be issues of damage. Because at present, the way litigation is going before these international courts is basically aiming at two issues. One is mitigation measures that should be implemented, and the second one is adaptation. So, this is where we are, and that means that, historical damage, for example, is not one of the issues that is coming to play a role in this context. So I'm dropping that there because I think I probably have gone beyond the time limit, and I want to engage with questions. Am I okay, Antonio? But
you have 2 minutes if you want.
Yes. So just to pick up on the Inter-American System, I think that we haven't yet had a case that reached the court, but I would say that that's, and why? Because we have all these issues of exhaustion of domestic remedies. Now, the case that Marc has been referring to in the European context, in his case, they didn't really go through filing claims domestically. The other cases he mentioned did, and that may be the reason why they eventually arrived more or less after some years. But the same would be required, let's say, in the Inter-American system, that the claim goes by a national court, etc. So it takes time, and that's a bit frustrating. However, there has been already some attempts to bring the climate change issue to the attention of the court. There was a very unfortunate case before the Commission and the Inuits, which was unfortunately denied, I would say, to be in process with and was dropped without a very good explanation, in my opinion. But I believe that a serious claim like that, if it were to come today, certainly would be producing a very different outcome. However, I would say that international litigation is just is enough that one case, even if it's in Europe, is decided and clarifies the law to have an impact on all the rest. So we won't be seeing cases all over in the international arena, but eventually, if there's one case that is successful, is going to have an impact on all the other jurisdictions that will have to adapt their domestic systems to comply with the manner how that treaty has been interpreted. So I'm leaving that there now, and let's have a little bit of debate.
Okay, thank you very much. It was very interesting. And as you were talking, I was thinking that I had to sort of qualify my previous statement about truth, because I understand that in some sense, for scientists and you guys, we're after a different kind of truth. In a legal procedure, the truth is what emerges from the evidence and from the documents that are in the process. That's not necessarily the truth, it's the truth of the process. That is a slight difference, but I think is important because they may lead to some confusion sometimes. And I think also the role of science is also complicated because we are sort of thinking like the only issue is to convince the judges, but in this procedure, there's also the other side, right? There is an opposition that probably has his own experts and is trying to devise strategy to discredit the experts on this side. And so in the end, I think there may be a situation in which the real issue is to ascertain what is the level of evidence that's sufficient to take it to reach a decision. And especially in a problem like this, where causal relations are very difficult to pinpoint. Mostly there we have statistical statements. And that's the reason for all the quotients in my fellow scientists. They're full of qualifiers. Whenever you ask them something, they're always saying, cautious. So if that's a level, and I think it's going to stay for a while. So the issue is then what is the level of, in some sense, the strength of the statistical statements that are needed in order to be to go above the noise levels of all different opinions, and then the judges are left with the idea that the situation is confused and we can't really decide what is true. So I think there is an issue there. So there are a few questions in the question and answer. There is a very long question that has been upvoted. I'll try to, I hope you can read it, but otherwise I'll try to summarize quickly. It's from Caroline Foster, and she's asking for Sandrine. And I think she has a question on the whaling case in Japan. And it's more like a comment on the fact that the court interpret in a special way what for scientific purposes means. So maybe Sandrine, if you can read the question, you can comment that in much more intelligent way than I did.
Okay, thank you. I read it. So, dear Caroline Foster, I know very well your work, which is really valuable. So thank you for your question, which is very interesting. So it's about the whaling case and the position of the International Court in the whaling case. My sense is that in the whaling case, the court has made some progress compared to its former decisions in the handling of the scientific aspects. but it still has been cautious, noting, for instance, that I quote, in applying the above standard of review, it is not called upon to resolve matters of scientific or whaling policy. The court is aware that members of the international community hold divergent views about the appropriate policy towards whales and whaling, but it is not for the court to settle these differences. And it tried to divide clearly between the facts, the technical and scientific issues, and the law, but it's not fully convincing on this point. But I would add that in reality, if we read carefully its decision, its judgment, in reality, it did consider advanced scientific and technical considerations, for instance, to assess if the sample size for statistical examination was reasonable, which was really technical, or if the use of lethal methods responded to a strict scientific necessity. So I think that the core, there is still room for improvement, but this decision represents a progress. And I think that there is another one from Caroline, a postcard.
Yes, is more like a follow-up to the previous one. And I think she said that when we read the pulp mills closely, the court denied reversal of the burden of proof in pulp mills only so far as this particular case was concerned. So I don't know if you have comments on that. It looks clear to me as a comment, but please.
Yeah, I would just like to add that, yes, I agree, of course. The court denied the reversal of the burden of proof for this particular case, but it explained that it saw no basis for this reversal in the interpreted treaty, which was the 1975 statute between the two, a treaty concluded by the two countries. And it explained that, in fact, nothing in the treaty justified to derogate to the general rule, which is onus probandi incumbit actori, meaning that the party which asserts certain facts has to establish the existence of such facts. So this is the general rule, and the court has reaffirmed this general rule. Thank you.
Thank you, Sandrine. And I think I would like to give the floor to Riccardo Luporini to ask a question from the floor.
Thank you very much. Yes, we have, I think, a very interesting, pertinent question by a participant in the seasonal school on climate change and international law here at the Scuola Superiore Sant'Anna in Pisa. The question comes from Costanza Cernusco, and it is about extraterritorial jurisdiction and science, and with regard in particular to the Portuguese case, to the Duarte and others case before the European Court of Human Rights. So I would address, I think, the question to Marc Willers in particular. So the question is the following: is science being used to bridge the gap between the global scope of the effects of greenhouse gases emissions and the primarily territorial or almost exclusive territorial jurisdiction of states under human rights law? If so, how? Thank you very much.
Thank you for that question. Very interesting question. I'm not sure that it's science that's necessarily bridging the gap. I think that it's international law that is being used, particularly in the Portuguese youth climate case, to explain how the 33 member states share responsibility for global climate change, along with the other member states around the world. The science helped in the argument as to the jurisdiction of the 32 member states outside of Portugal being in play, because it makes it clear to the court that those other member states have knowledge of the fact that the emissions that they are permitting, whether it be within their own territory or by the export of fossil fuels, or perhaps the import of fuels with which there are embedded emissions, or the financing by companies that are based within their countries of fossil fuel production, all that activity which is permitted by those member states is contributing to global warming, and that they are clearly knowledgeable about that. They know what is going on, and that in itself imposes a duty on them to ensure that there is that they regulate those activities so that harm isn't caused not just to their own citizens, but also to those in neighbouring countries and indeed around the world. And so in the European sphere, the 33 member states are all members of the Council of Europe and therefore subject to the European Convention on Human Rights. And so clearly there is an obligation under them, on those countries under the Convention, Articles 2, 8 and 14, to ensure that their activities and the activities of those within their territories do not affect those, not just, we would say, in their own domestic, within their own domestic boundaries, but also beyond that. So I'm not sure that science is actually bridging the gap. I think it might be more the principles of international law, some of which Sandrine has been referring us to. And indeed, you know, the pleadings in the Portuguese case rely on the principles of shared responsibility, some of which come from the judges in the International Court of Justice, and particularly Judge Seema. So, but the science itself underpins those arguments, as it does other elements of the case. One thing I would say is that in the Norwegian case, which is all about the activities of one particular member state, the fact is that the oil that is to be drilled in the Arctic, the Norwegian area of the Arctic, is likely to be exported, but then it will be burnt overseas, but nevertheless will contribute to global warming, which will then come back and bite or affect the Norwegian applicants. And so, again, the science shows that they will be affected, notwithstanding the fact that the oil to be produced will be exported outside of Norway. And so, you know, the science is good on that point too.
Antonio, can I add something to that?
Please, Monica, please.
Just on a comparative basis, I think it's a very good question. And I agree with Marc that this is not a question really for you know, scientific evidence. It's rather a pure treaty interpretation question. It doesn't even need you know, the principles that Sandrine was talking about. This is really about whether the specific provision on jurisdiction of a human rights treaty allows for you know, an interpretation that allows for this type of diagonal claims, that is violations of rights of individuals that are outside the territorial jurisdiction of the state that is being where, you know, where everything is coming from. So that's actually an issue that the Inter-American Court dealt with. Now, obviously, the treaty that the Inter-American Court interpreted is the American Convention. And what they decided in that case, when it came to interpreting issues of jurisdiction and environmental type of claims, they had a particular example of a transboundary type of harm. And the Inter-American Court, in this advisory opinion, did interpret the American Convention in a way that it could be possible for state A and B, so that the state A is let's say the state that is being sued, but is being sued by people that are living in state B. Why? Because there has been a transboundary harm. But that has been this is, for example, a new development before the Inter-American System. Is yet to be seen whether the European Court will follow a similar approach, and this is basically what we will be seeing in this particular case of the Portuguese Jews. I think it's a tough question for the judges, but we're looking forward to see what they decide in that case.
Thank you very much. And now the questions are coming fast. There is a question by Francesco Modei. He's asking if science is involved into the enforcing of judicial activities. Do international courts set science-based parameters to assure that damaging behavior is reversed or at least not repeated? Who wants to answer that? We're talking about science police here, I think.
So sorry, that for enforcement.
Yes, basically he wants to know if there is a role of science in the enforcement. Well, personally, I have a question on enforcement in general, how you make sure that enforcement is actually done at any level, but that's another story. The question here is if there is a role for science in the enforcement.
Yeah.
Who wants to try that? That's difficult. Yes.
I don't know. I mean, I can throw some views. I think that it would depend on the type of case. Before the ICJ, for example, there was this case that is not on environment, but it was a case that the dispute actually went on to for compensation to be paid, for example, so for an enforcement, for actually being able to have legal consequences. There was a separate moment where expertise was required, to assess damages and all of that. This was unique, and it was the first time ever before the ICJ. It's been an example where, expert evidence was required at that level. I cannot think of many cases like that in the climate context. Certainly on cases before the Human Rights Committee, it would be necessary, I think, to have scientific input to oversee, in a way, as lawyers, in a way, to make sure that things are being done properly. One will have to seek always to have, in a way, scientists, cooperating with the legal team, because the things that have to be implemented are complex. But otherwise, I would think that it's not a kind of a structured way, but rather, it's the normal way of implementing decisions. But obviously, lawyers, we never work alone, not even in cases that have not to do with the environment. Usually, my legal teams are mixed. So sure. I can see a role for scientists then. Yes.
Sure. I mean, facts are always useful, seems to be the conclusion to me. But I think Sandrine wanted to say something.
I just wanted to say the same idea. Just to mention that in 2015 and 18, in the Costa Rica Nicaragua case, the international court issued this second decision, this second judgment, focusing on compensation. So it was a very interesting judgment, even if the method of the court is not, the method that the court has followed is not very clear. But it has had to assess the environmental damage and to decide the amount of compensation, and science has been very helpful at this stage. And another element I would like to add is to answer, Antonio, what you mentioned about the level of evidence. In this judgment, the court, the international court, was showed itself quite open to a lower level of evidence in complex environmental cases, opening the door for probabilistic proof in such cases. And I think it could be interesting if we think of a climate case. Thank you.
Yeah, I mean, some statement like establish beyond any reasonable doubt, something like that, I would say. No, not really.
No, this is okay. Now, can we say something about that? This is very, you know, I'll say that that's why I talk about procedure from the beginning, because I think that's crucial. We have different levels of sophistication in national courts. Some domestic systems are far more sophisticated when it came to, you know, science being used in the context of domestic proceedings. I would say that the US more unpredictable, and the UK more predictable in how sophisticated and how that could be. But certainly in a civil law type of claim, you know, it's never beyond reasonable doubt. I mean, you know, it is just a civil standard for liability. In the international arena, so these are not international criminal cases. These are, you know, the equivalent of what would be a civil law type of standard of proof. And as Sandrine has mentioned, the ICJ, for example, quite clear, talk about circumstantial evidence, for example, being possible to be used, and also cumulative. Now, before the European Court of Human Rights, we have had statistical evidence, you know, being used to prove a point, and that was on a context of, and perhaps Marc may remember that it was about the schools and the children that were studying in those schools. So there was discrimination. There was not enough evidence on a single basis, but you know, the statistics show that generally these kids were always sent to schools that were for disabled type of or having challenges, and they were, you know, just because they were gypsy. And so I think that in the same type of, you know, approaches that tribunals may have had in other contexts can well be used in the context of environmental claims. And I would say also in the InterAmerican system, it's quite normal to have circumstantial evidence, you know, being put together. So what is important is obviously the cumulative effect of evidence. The most important evidence is the evidence that comes from the state itself. Because if I can win you with evidence that comes from you, you know, that I don't have to prove more. So I think that this is where we are talking about a very sophisticated understanding of how evidence, you know, is shown in every single tribunal and know very well the rules.
But I think this also shows the importance of the public science agencies, because those are producing those data that then can be used exactly in the context you mentioned, right?
You are so right, Antonio, and that's why I really encourage colleagues and scientists, you know, to publish and to write, because this potentially is very important. Give you one example in the context of investment arbitration and smoking tobacco. The most important piece of evidence in the most important investment arbitration that reached, you know, concerning human health, which was the Philip Morris case. Yeah. The key evidence was the evidence that came from the regional equivalent, you know, to WHO. So in the Inter-American system, that specific organ that deals with health, the Pan-American organization, provided the evidence of how smoking, you know, affects human health. Yeah. And that was the thing. So I could imagine that this type of intergovernmental organizations, you know, that produce evidence, all of that could be potentially extremely useful. And if they come as amicus, even, you know, in their own right, as well, it's potentially very useful. And I would say, you know, even scientists from universities, you know, that may eventually be able to contribute in that way as well.
Thank you very much. There is a question by Roberto that is basically sort of bearing on the different roles caused by the different level of emissions by different players, because there are disparity in the emissions between US, Europe, China. So is this fact taken into consideration, the fact that, you know, in some sense, different countries, of course, have different level of contribution to the problem? Oh, sorry, Mark wants to say something. I see your hand. Yeah.
Thanks, Antonio. I was just going to follow up by making a few points. Monica mentioned a Roma case. That was a DH against Czech Republic case, where the statistical evidence, I think, relating to the fact that Roma children were being disproportionately sent to special schools. So that, if anybody wanted to know which case that was it. And I agree that if you've got evidence from the state, which proves your point, so much the better. I mean, in the UK, we have the Climate Change Committee, which is continually banging the drum, indicating that the UK government is failing to adopt policies which will meet its high ambitions in terms of tackling climate change. And, you know, it's that sort of evidence that if you can rely on that, certainly at the domestic level, then, you know, you're halfway to proving your case, perhaps. In terms of the European Court of Human Rights, its judgments are, as it were, enforced by the Committee of Ministers of those member states of the Council of Europe, which will include, in the Portuguese case, should it be successful, ministers from the 33 member states. So it's a little bit like having the poacher looking after the game on an estate. It doesn't bode well, because the political situation. You've got ministers who are being required to ensure that judgments are executed when they've got their own political pressures at home. So I think there's a problem there. But scientists, although they perhaps can't act as enforcement officers, we don't have scientific enforcement officers, they can prove extremely useful if individuals in the member states that are challenged, for example, in the Portuguese case, then want to take their cases before the domestic courts, showing, relying upon a judgment from Strasbourg and then the evidence from a scientist to the effect that the member states are not complying with that judgment. And that's where the scientists, I think, will play a very important role in enforcing the judgment of the Strasbourg court back at home before domestic judges, who will be faced with a declaration from Strasbourg that the individual state has failed to tackle climate change, and evidence from a scientist or a bunch of scientists that steps have not been taken to properly comply with that judgment. So that's the way I think that scientists can act as police or enforcement officers in that regard. Thanks.
Okay, thank you very much. So maybe we can go back to the issue of the differentiated responsibilities among emitters. So anybody wants to give a comment?
About that. May I?
Sure.
Antonio, yes. So yes, I agree with the point. And in fact, this was a very important consideration, let's say, for example, to interpret obligations under the ICCPR, National Cabinet on Civil and Political Rights, because it's not the same, let's say, to sue Clivati or to sue Australia. So when, let's say, that an organ, a UN organ, is going to decide what the responsibilities of the states are under a particular treaty, states, obviously is there a point that has to be properly taken into account. That's why the Paris Agreement was very relevant as a context to be able to interpret this human rights treaty. Why? Because then there is a distinction of obviously differentiated responsibility. So not all states have obviously the same responsibility in targeting climate change, because some are more problem. And also the available resources that the states have. And to give you an example, that's why a key notion in the interpretation of these human rights treaties when it comes to state obligations is due diligence. And when one looks at that concept, one can see that because the capabilities of the states are different, and also because some states may be contributing to the problem more. Let's say there are more private entities from that state that are creating the problem, and they should be regulating them. There is that notion of whether they are doing enough, or whether they are following that duty of care towards the population that they are under the jurisdiction. The states, in principle, will obviously be assessed against its own the specific facts and contexts that are emerging from that situation. So that's why, every case is going to be different, but we are talking about some notions, I guess, that now have crystallized. For example, 2 years ago, you would ask, what is the standard of compliance, and nobody could have told you, So I think in this litigation that we did before the Human Rights Committees, we were the first ones to say, well, this is the standard of due diligence. So, so that's where I could contribute in trying to address that question.
Thank you very much. So maybe the last question is probably an easy one. Is from Yao Ming. He's asking what is the danger of having scientists on cross-examination, and how vulnerable they would be to smart lawyers? That's why I understand that question. So what's your opinion?
Thank you, my dear colleague Yao Ming Chu from Taiwan. Yes, I guess lawyers may try to orient the cross-examination process to influence.
That's their job, right?
Yes, it's part of the game.
Yeah.
But I think that the procedure before the court is quite detailed, and it's improving case by case. So it may limit the risks.
Well, I actually would advise scientists that would be considering participating, in procedures because the more you have experience, obviously, to be questioned in that context, the better. I have had, scientists that have unfortunately not been able to cope with the pressure, because cross-examination, particularly if it's done in the way that the common law system does it, it is not necessarily very easy or comfortable sometimes for a person that hasn't got experience. But I think that in a way, a scientist is an expert, so providing an opinion is not necessary. Partially, there is obviously factual aspects, but what the court is always going to take into consideration is that it's an expert evidence.
Oh, Marc, yes.
Yeah, I mean, I would recommend that anybody who is going to go in the witness box does receive some training, and I don't mean coaching on their evidence. Their evidence is expert, and they're the marshals of that, and they certainly should be true to their duty as an expert to the court, and not biased in one way or the other. But I do think that they ought to undergo some training, just as I think lawyers ought to have more training on climate science, and judges for that matter too, if that can be arranged. So tutorials either way, I think is like we're doing today, is something that is to be encouraged.
Yeah. Oh, that's a great idea for interdisciplinary training. Yeah. Okay, I think that we need to close. It's 5:30, so I would like to thank all the panelists for this very lively discussion. I think it was very interesting. I learned a few things. That's always useful. And so I would like to thank you again, everybody. And I think I'll give the floor to Christine, I guess. I'm not sure.